Hello and welcome back. Our last video introduced you to me and my class, and I defined the phrase legal writing. I hope I also debunked a common misunderstanding that legal writing is full of archaic terminology and legalese and difficult to understand. In this video, I'll define a related term, memorandum. A memorandum, or a memo, as we call it in casual conversation, is the quintessential piece of legal writing. And in fact, it's the quintessential piece of what we call objective legal writing. Objective legal writing is something that all attorneys will do at some point in their careers. And more important to you, it's something that all first-year law students across the nation are doing right now. A memorandum is a private document. It's not filed with the court, and it's not shared with opposing counsel. The only people who will see it are your colleagues and your clients. Therefore, attorneys writing memoranda should feel perfectly comfortable writing candidly. In fact, that's the whole point. The goal of a memorandum is to discuss a legal problem and predict frankly how a judge, jury, or other decision maker will resolve it. When we say objective, we mean impartial. As attorneys, we have to set aside our natural sympathies for our clients and write as a neutral, uninterested party would. After all, clients need to know the upsides and the downsides of their problems. If a lawsuit is on the horizon, they need to know whether they have a good, moderate, or poor chance of winning. A memorandum is essentially a research paper written by an attorney. The attorney first identifies the client's problem and then researches the law. This often involves reading cases dealing with similar issues. It's a candid paper that doesn't take a side. It discusses both the strengths and the weaknesses of the client's problem. Before I close, I want to define another phrase, persuasive legal writing. Persuasive legal writing is basically the opposite of objective legal writing. It takes place in a document we call a brief. This is a public document. It's filed with the court. It's shared with the adversary. The goal is to argue only the client's side of the case, to highlight the strengths and minimize the weaknesses. It's important to note, though, that in both objective and persuasive legal writing, the attorney always accurately identifies the legal framework. Moreover, in both types of writing, the attorney applies the law to the facts of the client's case. Finally, both types of writing are predictive. In a memorandum, the attorney predicts how the judge, jury, or other decision maker will resolve the case. In a brief, the attorney recommends or suggests to the court how the case ought to be decided. Law students across the nation spend the spring semester of their 1L year exploring persuasive legal writing. With that, you know a little bit more about objective and persuasive legal writing, about what law students across the country are doing right now, and about what this document you'll soon be writing, a memorandum, really is. Of course, this video is just a brief introduction to this topic. There's more information available in my textbook, Objectivity and Argumentation, a step-by-step approach to legal writing and oratory. Thanks, and see you next time.